הבאים לכנס השנתי הראשון על עריכת דין ציבורית-חברתית ולהשקת כתב העת מעשה משפט, שבאמצעותם אנחנו מקווים להעמיק את השיח על אותם מאפיינים שמייחדים את העיסוק בתחום. ואני שמחה להזמין את דיקן הפקולטה, פרופסור חנוך דגן, לפתוח את היום.
תודה רבה טל. אני שמח ונרגש לפתוח את הכנס השנתי הראשון לעריכת דין ציבורית-חברתית בישראל, שבו אנחנו גם משיקים, כמו שכבר נאמר, את כתב העת החדש מעשה משפט, כתב עת למשפט ולתיקון חברתי, שמופק על ידי התוכנית משפט בשירות הקהילה. הכנס וכתב העת משתלבים יפה בחזון של תוכנית המשפט בשירות הקהילה להוות גשר בין הפרקטיקה המשפטית לאקדמיה המשפטית, לשם פיתוחם של מודלים חדשניים של משפטנות ועריכת דין לזכויות אדם ולצדק חברתי. התוכנית החשובה הזאת, שמנווטת בשנים האחרונות ביד רמה על ידי עורכת דין טל קורמן, עסוקה בבחינת החסרים והחסמים הקיימים בשדה הזה, ובגיבוש כלים ואסטרטגיות משפטיים העונים לבעיות האלה. התוכנית יוצאת מהשדה המשפטי וחוזרת אליו. היא פונה לפרקטיקה של עריכת דין ציבורית-חברתית כדי לאתר בה צרכים ובעיות, והיא משתמשת במשאבים של האקדמיה כדי להעמיד תוצרים יישומיים לרשות ציבור עורכי הדין העוסקים בקידום זכויות אדם וצדק חברתי. ברוח זו, הכנס היום מתמקד באסטרטגיות חדשות של עריכת דין לקידום זכויות אדם וצדק חברתי, ויעלה כמה מהשאלות החשובות ביותר בתחום, כמו האם בכלל ראוי לפנות או למצער להדגיש את האפיק המשפטי, או שמא הסכנות הגלומות בפרקטיקה המסורתית של עריכת דין ציבורית-חברתית לקידום זכויות אדם וצדק חברתי גדולות מהיתרונות שלה. האם ראוי בצידה ובמקומה של עריכת הדין הציבורית-חברתית המסורתית לחפש ערוצים חדשים, דוגמת עריכת דין קהילתית כדי לקדם את הערכים האלה? איך מתמודדים, אם בכלל, הדפוסים החדשים של עריכת הדין הציבורית-חברתית עם המגבלות של השיח המשפטי, כפי שהוא עוצב על ידי הגישה המסורתית יותר? האם ניתן ואיך לשלב בין אקטיביזם חברתי, קהילתי, פוליטי, לבין התדיינות משפטית וקידום חקיקה, באופן שאולי ישביח את שני האפיקים האלה גם יחד? ואילו לקחים ניתן ללמוד מכל השאלות התיאורטיות האלו וליישם אותם למציאות הישראלית ועוד ועוד. כפי שציינתי בראשית דבריי, הכנס הזה משמש גם כאירוע השקה של כתב העת החדש מעשה משפט. ההצטרפות של כתב העת החשוב הזה למדף כתבי העת המשפטיים בישראל היא יום חג. כתב העת הזה, שהוא פרי יוזמה ברוכה של תוכנית המשפט בשירות הקהילה, מביא קול מיוחד לשיח המשפטי בישראל. כמו התוכנית הזאת, גם מעשה משפט מחדד שילוב מיוחד במינו בין המחויבות האקדמית למלומדות משפטית לבין המחויבות הערכית לתיקון חברתי. כתב העת מצוי במילים אחרות בקו התפר שבין אקדמיה לפרקטיקה. הוא מכוון לשמש במה לעשייה הרבה הנעשית בישראל ומחוצה לה בתחום עריכת הדין הציבורית-חברתית, בתוכניות לחינוך משפטי קליני, בארגונים חברתיים ובקרב עורכי דין מהמגזר הציבורי והפרטי, והוא גם מהווה פורום לעיון ולליבון המשמעויות התיאורטיות והמעשיות של הפעילות הזאת, כמו גם של ההגות הכללית ביותר באשר לקשר שבין משפט לבין שינוי חברתי. ואולי חשוב מכל, הוא מבקש, כפי שמציין עופר סיטבון, העורך הראשי שלו, שתכף יחליף אותי כאן, לשבור, אני מצטט, לשבור את המחיצות הקיימות בין הכתיבה האקדמית לבין העשייה המשפטנית בשטח, ולהפוך את הכתיבה בו לאופציה שהיא אטרקטיבית גם למי שהעומס המוטל עליו, בקליניקה, בארגון או במשרד עורכי הדין, גורם לו או לה לחשוב בטעות שאין ביכולתם לכתוב מאמרים ראויים לפרסום. אכן, כפי שעופר מציין בצדק, הידע והניסיון המעשי של כותבות וכותבים פוטנציאליים אלו, רבים מהם יושבים כאן, יכולים להיות בעלי עניין רב, הן לעוסקים בעריכת דין חברתית, והן למתעניינים בהיבטיה התיאורטיים. רציתי להודות בשמי ובשם הפקולטה למשפטים לכמה נשים ואנשים שבלעדיהם כל ההפקה, החל מכתב העת וכלה בכנס, לא הייתה קורמת אור וגידים. לכותבים, שזכו להיכלל בכנס הראשון של מעשי משפט. To Professor Scott Cummins, that arrived here especially to this conference and went out of his way to contribute to the success of this first and exciting event, the first of its kind in Israel. לחברות מערכת כתב העת, אלישבע אביצור, מאיה מרק, נטע פטריק ושירה שמואלי, כולן בוגרות הפקולטה ויוצאות כתב העת הוותיק שלנו, עיוני משפט, אשר שילבו בעבודה שלהן שנעשתה בהתנדבות. כך נאמר לי, גם הדבר הבא כך נאמר לי, רגע, תקשיבו לזה, שילבו דעתנות ומקצוענות עם אידיאליזם ושיתופיות. עכשיו מחיאות כפיים. לוועדה האקדמית, פרופסור דפנה ברק ארז, דוקטור נטע זיו ודוקטור גילה שטופלר, שהתוו יחד עם טל ועופר, להם אני אגיע עוד רגע, את הקו המיוחד של כתב העת, תוך שילוב של הניסיון שלהן, יחד עם הסטנדרטים המקצועיים המעולים שהם הביאו לתמונה, וכמובן לטל קורמן, מנהלת תוכנית המשפט בשירות הקהילה, והמנהלת המקצועית של מעשי משפט, ולעופר סיטבון, העורך הראשי של כתב העת, על שהובילו את המהלך עד ללידה שאותה אנחנו חוגגים היום. בעזרת הוועדה האקדמית וחברות המערכת, הצלחתם בגדול, ביצירה יש מאין של משהו שהוא שונה, חדש, מיוחד וחשוב. ועוד מילה אחרונה. אני מאמין, ונדמה לי שלהאמנה הזו שותפים רוב, אם לא כל חבריי בפקולטה, שערכים אקדמיים של מלומדות משפטית וחינוך משפטי מזה, ומחויבות נורמטיבית לזכויות האדם ולצדק חברתי מזה, אינם טובים אנושיים מתחרים שצריך לאזן ביניהם, אלא מהווים דווקא רכיבים משלימים, הכרוכים ושזורים זה בזה. הכנס החשוב הזה וכתב העת המצוין שאנחנו משיקים בו הם דוגמאות חשובות לאמיתה הזו. אני מאחל לכולנו כנס מרתק ומודה שוב לטל, לעופר ולכל מי שסייעו בידם כדי להגיע ליום הזה. תודה רבה.
רשימת התודות המובאת בפתח הכרך הראשון של מעשי משפט היא ארוכה מאוד, כמתבקש מעבודת צוות מאומצת. ואולם כאן ביום חגו של מעשי משפט, שהוא גם, כך אני מקווה, יום חגה של עריכת הדין החברתית והציבורית בישראל, אני מרגיש בכל זאת חובה מיוחדת להודות פעם נוספת לשותפות המרכזיות לעשייה. הפקולטה למשפטים בתל-אביב, בראשות הדיקן פרופסור חנוך דגן, שפרסה את חסותה על כתב העת. לחברות התומכות בוועדה האקדמית, פרופסור דפנה ברק ארז, דוקטור נטע זיו, דוקטור גילה שטופלר. חברות המערכת המבריקות, זה שם תואר שעדיין לא השתמשו, אלישבע אביצור, מאיה מרק, נטע פטריק ושירה שמואלי. וכמובן, איך אפשר לא, למנהלת המשפט בשירות הקהילה, עורכת הדין טל קורמן, שתושייתה ומחויבותה לא ידעו גבול, ושמידת ההקפדה שלה על פרטים הציבה רף חדש למילה פרפקציוניזם. על כולן נפות תבוא הברכה. הקמתו של מעשי משפט נועדה בראש ובראשונה לענות על חסר, היעדרה של במה לדיון ולעיון בשאלות הלקוחות משדה עריכת הדין הציבורית-חברתית בישראל. שיחות שיצא לי לקיים בחודשים האחרונים עם פעילים ופעילות חברתיים רבים, משפטנים ולא משפטנים כאחד, המחישו לי עד כמה הבמה הזו נחוצה. עבודת השטח מציפה בעיות ודילמות יומיומיות, המשותפות לרבים ולרבות מהפעילים והפעילות. המתח שבין הצדק והתיקון הכללי לבין הצדקה והחסד הנקודתי. המתח שבין הרצון לפתור את הבעיה עבור הפונה לבין השאיפה להעצימו. בנוסף, רבים מקרב הפעילים והפעילות חשים שסיסמאות כלליות ואינטואיציות אינן מספיקות עוד, וכי אנו זקוקים להמשגה ולכלי ניתוח עדינים ומתוחכמים יותר. במילים אחרות, עלינו לפתח ביחד שפה חדשה. מה שעוד התבהר לי, הוא שיותר מאשר בדיסציפלינות אחרות, האמרה שלפיה מרוב עצים לא רואים את היער, נכונה במיוחד לעריכת הדין החברתית. דימוי אחר שניתן לעניין זה הוא כי לא מספיק להרוג את היתושים, אלא צריך לייבש את הביצה. במילים אחרות, נטולות דימויים וקלישאות, המשפטנים החברתיים הם קבוצת עילית של אנשי מקצוע אכפתיים, יצירתיים, אידיאליסטים, החיים את השטח ומכירים מקרוב את התחלואים החברתיים המרובים. עשייתם אמנם ברוכה ואמיצה, אך היא גם לא פעם נקודתית ומקוטעת. לא אחת חסר לה סדר יום פנימי קוהרנטי שכולל את חזון התיקון החברתי הכולל. אנו מקווים שהופעתו של מעשי משפט תוכל לתרום לגיוס ולליכוד כלל אוכלוסיית הפועלים והפועלות לשינוי חברתי, ותסייע להם ולנו לעצור כדי להתבונן בתמונה הכוללת הנשקפת מבעד לאין ספור המאבקים היומיומיים המפוזרים. אנו מקווים שזו תהיה הבמה שבה יוצגו הלבטים היומיומיים, אך גם תובלטנה ההשלכות החברתיות הכלליות, שבה יעסקו במאבק הקונקרטי למען חולה אחד הדורש מקופת החולים שלו את התרופה לה הוא זקוק, אך גם בהקשרים המשפטיים, החברתיים והכלכליים שהובילו אותו ואותנו למצב הזה. מעשי משפט ינסה לתרגם ממיטב הכתיבה בנושא עריכת הדין החברתית, אך הוא יבקש גם להבליט את מאפייניה הייחודיים של משפטנות חברתית נוסח ישראל. ואכן, בעשורים האחרונים התפתחה בישראל מסיבות מגוונות עשייה משפטית ענפה ורבת פנים, המכוונת להגנה על זכויות אדם ולקידומו של צדק חלוקתי. פעילות זו נעשית בזירות רבות, שכולן מיוצגות בקרב משתתפי הכנס הזה. עורכי הדין במגזר הציבורי, בארגונים החברתיים, בקליניקות, בקרב עורכי הדין הפרטיים. משפטנים אלו, אתם, תופסים את המקצוע המשפטי כמקצוע ציבורי, כחלק מאליטה משרתת, בעלת מחויבות חברתית ומוסרית. העשייה הברוכה הזאת, למען חלוקה צודקת יותר של המשאבים הציבוריים, למען העצמתן של אוכלוסיות מוחלשות, למען פיתוח סביבתי בר קיימא, היא בעלת חשיבות שקשה להפריז בהשלכותיה. המאבק שמובילים עורכי דין ציבוריים נגד הפרטת בתי הסוהר למשל, מעלה בעוצמה רבה לסדר היום את השאלה הכללית בדבר גבולות ההפרטה ואף גבולות הריבונות המדינתית. הסיוע שנותנים משפטנים חברתיים לעובדים המנסים לממש את זכותם החוקתית הבסיסית להתארגן בבתי קפה, במפעלי טקסטיל או אף בין כתליו של עיתון יומי מכובד, הסיוע הזה מציף לתודעה הציבורית את אווירת הג'ונגל שבה שרויים כיום יחסי העבודה במשק הישראלי ואת התרופפותה של הסולידריות החברתית. ההתגייסות למען אוכלוסיית מבקשי המקלט מדארפור הובילה לשינוי מעמדם של פליטים אלו, מנתיני מדינת אויב לבעלי תעודת זהות ישראלית. החקיקה המתקדמת בנושאים מגוונים כדוגמת זכויות אנשים עם מוגבלויות, מניעת הטרדה מינית או חופש מידע לא הייתה יכולה להיות כזו ללא מעורבות של משפטנים בעלי מחויבות חברתית עמוקה בשירות הציבורי ובארגוני החברה האזרחית. והרשימה עודה ארוכה מאוד מאוד. העשייה המשפטית החברתית משקפת אידיאליזם מפוקח. היא מבקשת לעשות שימוש בכלים המקצועיים ובהון החברתי הניכר המתלווים לפרופסיה המשפטית, על מנת לאתגר את קווי הגבול בין המשפטי והמקצועי לבין הפוליטי. זאת במטרה לקדם תיקון חברתי כולל. בהקשר זה האתגרים הניצבים בפנינו כיום מורכבים יותר מאשר בעבר. ההבחנה הליברלית הקלאסית בין הפרטי לציבורי, התפיסה כי המדינה היא האחראית הבלעדית להבטחת ההגנה על זכויות אדם, הבחנות אלה הולכות ומטשטשות. תהליכי ההפרטה נמשכים בעולם וגם בישראל גורמים לכך שמספר גדל והולך של תאגידי ענק ממלאים כיום תפקידים שלטוניים מובהקים. משמעות הדברים היא כי המדינה איננה עוד השחקן היחיד במגרש, וכי גם גופים פרטיים יכולים לפגוע ואכן פוגעים בפועל בזכויות האדם, בצדק הסביבתי או ברקמה הקהילתית המשותפת. כפי שנשמע מיד מפרופסור קמינגס, עורכי הדין החברתיים בעולם וגם בישראל ניצבים בפני אפיקי פעולה חדשים. כידוע, קיימת ביקורת לא מועטה על המשפטיזציה של החברה, ועל כך שהפנייה לערוצים המשפטיים חוסמת פנייה לאפיקי פעולה פוליטיים ואחרים שיכלו אולי להיות אפקטיביים יותר. אף שבביקורת זו יש מן הממש, הדוגמאות הרבות שהזכרתי ממחישות את מרכזיותה של העשייה המשפטית החברתית. סדר ללא חוק או למצער, שמירה על ניטרליות, הם הפריבילגיה של החזקים בחברה. הצעידה בנתיבים המשפטיים קידמה שינויים חברתיים מרחיקי לכת. וכפי שכתבה פרופסור אורלי ליבל במאמר מבריק שהתפרסם בהרווארד לו ריוויו ושתרגומו המעובד מופיע בכרך הראשון שלנו, המשפט הוא ביסודו דיסציפלינה אופטימית. כתב העת מעשה משפט מציע אפוא סדר יום חדש לדיון המשפטי התיאורטי בישראל. אך כאמור, הוא מבקש להוות יותר מאשר במה עיונית ומחקרית גריידה. גדול תלמוד המביא לידי מעשה, אמרו חז"ל, וכך גם מטרתו של כתב העת, היא ליטול חלק במאבק על תיקון פניה של החברה הישראלית. מכאן אפוא מופנית קריאתי עליכם, אנשי אקדמיה, קלינאים, יועצים משפטיים ופרקליטים. אנא, הענו לקול הקורא המצורף לחוברת שלכם, שבידיכם. אנו רוצים לשמוע את מחשבותיכם על אודות מאמרי הכרך הראשון, מחכים לתובנות שלכם, מצפים למאמרים שלכם, וכמובן יותר מכל מצפים למעשים שלכם ושלנו. לסיום רציתי לקרוא לכם מתוך שיר שנכתב אמנם לפני 80 שנה, החלט המגייס והאידיאליסטי שלו עדיין מצליח, אני חושב, לרגש. כאן על פני האדמה, מאת רחל. כאן על פני אדמה, לא באבים מעל, על פני אדמה הקרובה האם. לא ערפילי מחר, היום המומש ביד, היום המוצק, החם, האיתן. לרבות את היום הזה, הקצר, האחד, על פני אדמתנו כאן. בטרם עתה הליל, בואו, בואו הכל, מאמץ מאוחד, עקשני וער של 1000 זרועות. האומנם ייבצר לגול את האבן מפי הבאר? תודה רבה לכולכם ושיהיה לנו כנס מוצלח
I'm honored and delighted to ask to the podium Professor Scott Cummings from the UCLA School of Law, Faculty Chair of the Epstein Program in Public Interest Law and Policy, who not only accepted our offer to come and serve as our keynote speaker so willingly and enthusiastically, but was generous enough to describe it as his own privilege. Thank you.
Good afternoon, everyone. I'll describe it again as a tremendous privilege to be here today to celebrate with you the inaugural conference on public interest law in Israel and the launch of the Social Change Law Journal. I want to first express my deep, deep gratitude to Tal Korman, without whom none of us would be here, and who I think serves as a powerful reminder of the transformative potential of individual action and individual vision. Thank you, Tal, for the wonderful gift of bringing us all here today. I'd like to also thank Ned Aziv, who has been an inspirational force for me and for public interest lawyers around the world. I speak to you today with both deep humility and tremendous excitement, feelings I believe that are both born from my conflicting sense of identity here as an American in Tel Aviv, invited to speak about the powerful and complex topic of public interest law. My humility stems from my profound sense of being an outsider, broadly to the global dimensions of public interest law, and more specifically to what is happening here in Israel. From a global perspective, I stand here at a time of tremendous ferment within public interest law. There's been an explosion of public interest law programs across the globe, marking a new wave of public interest institution building, one that shares the same optimism and vitality of earlier efforts in South America and South Africa in the 1980s, but that is now as committed to building the rule of law in developing and transitional countries as it is to resisting oppression by authoritarian regimes. We are now living in a period where the concept of public interest law is therefore being rearticulated and adapted to the post-Cold War political context in new and dynamic ways. Innovations are coming from new locations, networks are forming across national borders, and lawyers in places as diverse as Poland, Bangladesh, China, and Brazil are investing the notion of public interest law with new meaning and new force. I'm also here as an outsider to Israeli law and politics, conversant in many of its central political narratives, yet unfamiliar with the political and jurisprudential terrain on which the contest for social justice is played out. While I understand the outlines, I cannot claim to know the texture. I'm certain that I will leave here today with a deeper appreciation of the challenges that you all face in the project of using law to redistribute power to those to whom it has been denied. So as a good public interest lawyer, I'm here to learn as well as to teach. Yet it's precisely my shared identity as a public interest lawyer that generates my tremendous excitement, which grows from looking around this room and realizing that though I am 7,500 miles away from my home in Los Angeles, I nonetheless stand surrounded by friends and allies in a political and intellectual space bounded by fidelity to principles of struggle and justice. In this sense, I feel like an insider, sheltered by the warm familiarity of common cause and shared commitment that knits us together in an international network of social change lawyers. In this mode, I'm here both as an academic researcher of public interest law and as a fellow practitioner, someone who worked in the field of community economic development before entering the legal academy and who continues to support anti-poverty efforts in Los Angeles through my own law school's clinical program. I therefore cannot claim political neutrality on this day. To the contrary, I am, like all of you, deeply committed to promoting justice through law. Yet what I can offer to you as my newfound friends, I think, is a frankness, a promise to convey my observations with an objectivity that I hope can guide us in appraising the transformative potential of the public interest law movement at this particular historical moment. So what is this moment? Again, I cannot speak to developments in all places, so I must confine myself to the American experience. And I do this with great sensitivity to the tendency within the public interest law scholarship, at least, to take the U.S. experience as paradigmatic. So I want to make it clear at the outset that I do not claim the universality of the American experience to any degree, but rather want to try to emphasize its partiality as well as its increasing dependence on international resources. I therefore hope to use the U.S. as a frame of reference, a window on the challenges confronting what remains the most highly institutionalized public interest law system in the world 4 decades after its birth. From this vantage point, I suggest that the contemporary moment in American public interest law is fundamentally a transitional one. It is neither optimistic nor pessimistic in its basic ideology. It is neither top-down nor bottom-up in its tactical orientation. And public interest lawyers, a term that covers a very broad range of actors, are considered neither political insiders nor political pariahs. So how did the public interest law movement in the U.S. arrive at this crossroads, and what lessons might we draw, not just for American lawyers, but very tentatively for public interest lawyers around the world? To answer this question, to try to answer this question, my remarks will proceed as follows. I want to begin by briefly situating the U.S. experience in historical context, reprising both its dramatic rise as a social change tool in the 1950s through 1970s and the resultant challenges to its liberal agenda. I then want to spend some time examining what I think are the major institutional responses to these challenges by lawyers on the political left, which I suggest mark the resurgence of public interest law, albeit in a slightly different form. And finally, I want to conclude by articulating some of the central lessons of the U.S. experience so far, and what, if any, and again, this would be very tentative, but what, if any, application they might have to the Israeli context. This is going to be a synthetic account, and as such, it will necessarily sacrifice some depth for breadth. So I'm going to paint the broad outlines and not the deep texture. So let me begin with a brief account of the historical trajectory of public interest law in the United States. Of course, public interest law everywhere is an intrinsically idealistic enterprise. At its core is the notion that those with power will listen to the force of legal arguments and change their actions to benefit the less powerful in the name of legal justice. As such, I think it always constitutes a leap of faith. The U.S. public interest law system at its inception was built upon precisely this type of legal idealism. In very, very general terms, its central operating premises were these. First, that law could trump politics, which is to say that it could effectively check abuses of political power. Lawyers could go to court and gain a definitive ruling from judges in favor of marginalized clients that political decision makers were forced to accept. This, yes? Slower? Oh, sorry. Slower, okay. I'm not good at slow. So do you want me to start back at the beginning? Okay, so, what's that? Take it from here. It's okay, very good. Thank you. So, again, in terms of the central principles of public interest law, the first being that law could potentially trump politics. lawyers could go to court, lawyers could gain a definitive ruling from judges in favor of clients that decision makers were forced to accept. Government would enforce rules and citizens would adhere to the rule of law. This optimistic picture of social change through law fed into a second operating principle, which was that legal action could, in the right circumstances, operate as a substitute for political action. The idea was that when minority groups could not influence the levers of political power directly to improve their conditions, legal action or law could substitute as a form of politics, thereby converting their political weakness into strength through the activation of legal rights. These premises were placed into action through the vehicle of the impact lawsuit in the United States, and I sort of sketch it diagrammatically here. The impact model used strategic lawsuits to articulate federal policy through courts. It thus presupposed the existence of a strong federal government that could both decree and enforce legal mandates against state and market actors to benefit politically underrepresented groups. I should say that the impact model was never the only form of legal activism in the United States. Public interest lawyers have long conducted a broad range of tasks, from lobbying the legislature to supporting grassroots organizing. However, the impact model was firmly identified with first-wave public interest lawyering in the public eye. So there are two complementary strategies that lawyers deployed under the auspices of impact litigation. On one side was the right strategy, in which lawyers at public interest law firms, or PILFs, brought suits on behalf of underrepresented groups, invoking federal constitutional or statutory rights to redress the abuses of state and market actors. The classic example here is the campaign by the National Association for the Advancement of Colored People's Legal Defense and Education Fund to end public school segregation in the United States by suing local school districts in federal court under the Equal Protection Clause of the U.S. Constitution. On the other side of the ledger here was a regulatory strategy in which lawyers sued federal agencies with regulatory authority over defined market actors in order to enforce statutory mandates protecting the public interest. So here the classic example was of environmental and consumer groups using law to monitor and enforce regulatory agent activity to hold industry actors accountable to the public good. In the 1980s, I suggest, marked a turning point in the trajectory of U.S. public interest law, signaling a conservative backlash against the principles that the public interest law movement had sought to inscribe into law. The challenges to public interest law can be described as threefold, taking the forms of domestic political opposition, international economic transformation, and a growing sense of disillusionment with law as a social change tool and a social change model. Domestic political opposition came from two directions. From inside the movement, there was a highly effective effort to contest the meaning of public interest law by conservatives who established a countervailing set of legal organizations dedicated to advancing a right-wing political agenda under the rubric of serving the public interest. On the most contentious socio-political issues of the day, liberal public interest groups standing for economic regulation, redistributive social welfare, the separation of church and state, the rights of criminal defendants, and protection for minority groups, increasingly found themselves pitted against their conservative counterparts advocating a mirror image agenda: free markets, small government, a prominent role for religion in public life, law and order, and an end to affirmative action. With the concept of public interest law thus cast into doubt, a more ample term was needed to describe the collective advocacy project. And as a result, I think we are now all, those on the left and the right, cause lawyers, not public interest lawyers, advancing competing notions of the public good. The emergence of right-wing legal groups reflected the broader rise of domestic conservatism as a political force and the transformation of the political terrain outside the public interest law movement. From an advocacy perspective, the major change was the declining role of the federal government as a guarantor of legal rights associated with political liberalism. This was most striking in the judicial arena, where the struggle over the ideological composition of the federal branch began to move the weight of the federal courts toward a constitutional vision that was skeptical of economic regulation and skeptical of minority rights. The federal courts, once deemed the final arbiter of liberal claims to social justice, was transformed into, at best, an unreliable ally for public interest lawyers, and at worst, a hostile enemy to be avoided. So the classic liberal rights strategy was, if not undone, severely weakened by this move. In addition, public interest lawyers were themselves attacked in the U.S., most notably in the successful effort to restrict the scope of advocacy that could be undertaken by legal aid lawyers to the most routine individual service cases. The domestic political movement complemented the rise of neoliberal market integration policies at the international level. This version of neoliberalism embraced an asymmetrical model of the free market, symbolized by the North American Free Trade Agreement, which broke down barriers to the mobility of capital and goods on the one hand, while strengthening obstacles to the movement of labor on the other. This asymmetry, I suggest, further destabilized the domestic environment for public interest law. The outflow of corporate activity to developing countries with minimal regulatory regimes fundamentally challenged the classic public interest law regulatory strategy. Corporate actors that wanted to avoid regulation fled to countries with cheap labor and low environmental standards, while the domestic regulatory and social welfare systems were weakened in the name of economic competitiveness. Free trade, in turn, produced its own market dislocations in developing countries, which fueled increased levels of outmigration, particularly from Mexico, generating a surge in illegal entry to the United States that confronted U.S. public interest lawyers with a wave of legally disempowered economic refugees. Well, the obstacles to public interest law asserted by these domestic and international shifts fed a sense of disillusionment with public interest law, articulated in a way that reversed the idealistic formulation that animated the early public interest law movement. So instead of viewing law as able to check politics, the narrative of disillusionment suggested that law was just politics, and an inadequate version of politics at that, and therefore could not countermand political abuse. This, in turn, upended the notion that legal mobilization could effectively take the place of political mobilization. If law was an inferior form of politics, this argument went, privileging law risked diverting scarce resources from other types of more effective collective action. Paradoxically, I think, this narrative of disillusionment has continued to resonate even as the institution of public interest law has grown in size and complexity in the United States. Indeed, as the modal public interest organization has grown from 7 to 17 lawyers over the past 30 years, and evidence suggests that lawyers have shifted at least some of their strategies away from traditional litigation, cries of lawyers dominating poor clients and derailing social movements have continued unabated. The sort of public interest version, I would suggest, of the more general public disaffection with the burgeoning private bar. This apparent mismatch between the ideology and institution of public interest law begs a central question. If the idealistic vision of public interest law that motivated its creation is indeed dead, what explains its robust institutional expansion? Has the growth of public interest law been a version of path dependence, with organizations reflexively vying for greater resources and status as members of a competitive professional environment? Alternatively, have lawyers willfully ignored the criticisms of law as a social change tool, deluding themselves about their social relevance to preserve their professional status and legitimacy? Or have the critics themselves missed something about the efficacy and vitality of the public interest law movement? I'm not able here today to answer these complicated questions in any definitive way. Instead, I would like to offer an alternative reading of the contemporary public interest law scene in the U.S. that displaces the narrative of disillusionment with one of public interest law's resilience in the face of powerful opposition. According to this story, focusing on the ways in which liberal advocacy has been circumscribed is, while no doubt important in drawing attention to the need for structural reforms, in one sense to see the glass as half empty. That is, there's another side of the modern public interest law movement that sounds in innovation rather than in constraint, that reflects political sophistication and tactical flexibility rather than unreflective fealty to the logic of legal reform. Whether this reading is more powerful than the alternatives, I'm not sure, but I want to suggest that it is at least plausible reading by articulating three programmatic responses that contemporary public interest law has asserted to the historical challenge that I've just articulated. Strategic adaptation in the face of domestic political opposition, internationalization in the face of global economic transformation, and pragmatism as an antidote to disillusionment. Let me start here with the notion of strategic adaptation. One way to think about what has happened within public interest law is to map advocacy efforts along a geographic continuum spanning from the center to the periphery. That is to say that one response to the constriction of the federal court system in the U.S. as a means for advancing policy reform through litigation can be seen in lawyers intervening in other tiers of government as a way of influencing political decision-making. We might view this as a shift away from centralized legal contestation in the form of the federal impact lawsuit that I just described to a model of multi-level advocacy in which lawyers target efforts to decision-making tiers viewed as most susceptible to their efforts. Within this system, the federal lawsuit still plays a very critical role, but litigating to the Supreme Court, which was the old model, to win favorable precedent is no longer the sine qua non of federal advocacy. Instead, federal litigation is selective in the sense that lawyers carefully weigh the pros and cons of bringing important issues before federal judges who may view their claims with skepticism. Federal court litigation, then, may proceed when advocates believe that the issues at hand are so egregious as to compel even the most conservative justice to change position, or that there are no viable alternatives, and so losing in court would leave litigants no worse off than if they had not raised their claims at all. We have therefore seen over the past several years a string of Supreme Court victories on issues of gay rights and the death penalty, where the court has been persuaded to overturn laws viewed as out of step with mainstream social values. And of course, we have witnessed what is perhaps the most prominent test case impact litigation of the post-9/11 era in the United States, which is the contest over the detention of so-called enemy combatants at Guantanamo Bay, in which high-profile U.S. public interest organizations have represented detained foreign nationals, securing important judicial victories, upholding the right to petition courts for relief, and striking down defective procedures for reviewing detainee status. These detention cases, of course, have presented classic questions of access to justice and the balance of power, whether detainees have access to due process to challenge the basis of their confinement, and whether the executive branch in the United States may unilaterally set the rules. And the Supreme Court has thus far, at least, sided with the rule of law over the exercise of arbitrary power in the name of national security. There are other areas as well in which lawyers still turn to the federal court to enforce rights. In the immigration context in the United States, for example, federal law actually offers limited labor rights for undocumented workers that lawyers have used to protect them in the workplace. Where the federal court is not a viable option, however, lawyers have had to weigh alternatives such as state court advocacy and non-litigation strategies. At the state level, there are many, many examples of lawyers turning to state courts with more hospitable judges and more protective laws to advance liberal advocacy claims. In California, for example, in the garment industry, lawyers have begun to rely more heavily on state law causes of action to recover unpaid wages for immigrant workers in production sweatshops, and have successfully organized to pass statewide legislation holding garment retailers and manufacturers liable for the labor violations of their contractors. Legal groups have also invested resources in efforts to influence local governmental actors. In the labor context, one example of this has been the effort to pass municipal living wage laws that raise the minimum wage above the federal level for workers in businesses that receive local contracts or local subsidies. Another prominent example has been local efforts to pass legislation blocking the establishment of big box retail stores like Walmart that threaten to lower wages and benefits, or at least conditioning their entry into the local market on the promise to raise labor standards. At the sublocal, community-based level, lawyers have also invested significant resources in supporting community organizations that seek not to influence local decision-making per se, but to instead create alternative organizational structures to promote community-based economic development and affordable housing. These efforts, grouped under the rubric of community economic development, have seen lawyers eschewing the role of litigator altogether and instead providing transactional legal assistance, helping groups from form nonprofit and for-profit legal entities, advising them on tax and real estate matters, and assisting them in structuring complicated deals to leverage outside investment to promote community economic development. Another example of this community-based trend has centered on community coalitions that have organized to extract enforceable contractual benefits from private developers in the form of resources for housing and commitments to provide local residents with living wage jobs in exchange for community support for commercial development projects. Critics of localism have focused on the shift away from traditional legal engagement as part of a potentially dangerous trend of opting out of the broader context over the definition of universal legal rules at the precise moment that conservative and corporate opponents of political liberalism are aggressively pursuing their interests through the law. Though we are wise to be cautious, I think, that the quest for localism does not spell the demise of broader legal engagement, it is worth noting that many of the most sophisticated efforts to promote these types of local reform efforts that I'm suggesting are quite skillful in not only promoting grassroots community mobilization and self-help, but also deploying legal activism to change law on the books. So there are important examples in the United States of immigrant groups using local advocacy strategies to amend state labor laws and reform abusive industry labor practice vis-a-vis immigrant workers. Similarly, while the community economic development movement provides a leading example of decentralized community-based activism in the non-governmental sphere, it too encompasses efforts not just to promote citizen participation, but to translate participation into citywide legal reforms to hold local developers accountable for improving labor standards and expanding affordable housing. The issue then becomes how to diffuse these local reforms on a national level, an effort that is evolving through the establishment of national organizations that play a role coordinating local efforts and disseminating information about local successes. So I suggest here that we could view these efforts at adaptation to domestic political opposition graphically as a sort of redistribution of advocacy efforts within the system of U.S. federalism away from the federal level, sort of down the ladder here, toward lower tiers of governmental and community-based decision-making. Of course, this notion of multi-level engagement has a very long lineage within the public interest law movement. However, what I'm suggesting here is that it's possible that we are now seeing a reallocation of efforts toward the local in the face of the contemporary opportunity structure for legal activism. Let me turn next to changes in the international realm. As we have seen economic globalization reducing barriers to free trade and capital flows, thus making it more difficult to regulate corporate activity in the United States, we've also seen it opening up opportunities for new forms of public interest advocacy. What I want to suggest here is that while globalization has promoted a market integration, a free market agenda that has challenged public interest law, it has also produced new opportunities for innovative advocacy, stimulating the International Human Rights Network and facilitating the development of transnational advocacy networks that have reinterpreted public interest law's tactical repertoire and strategic aims. For U.S. public interest lawyers, there is currently tremendous interest in bringing human rights home, that is, applying human rights to advance domestic advocacy goals. This picture of American public interest lawyers, who a generation ago championed the transformation of domestic law for progressive ends, now turning to human rights as a sort of master frame for social change, highlights the contrasting fortunes of the public interest law movement at home and its human rights counterpart abroad. While the international human rights system was promoted by the U.S. in the Cold War era as part of a way to export American-style public interest law to activists in foreign countries resisting authoritarian regimes, the current U.S. human rights movement represents an effort by public interest lawyers there to import the very norms and methods built through international struggle to contest what they view as the erosion of domestic legal standards due to domestic conservatism, neoliberalism, and the war on terror. So whereas the classic public interest model centered on precedent-setting federal court litigation, domestic human rights advocacy seeks to incorporate rights norms through multiple ports of entry. By no means have domestic human rights advocates given up the high-stakes federal court case, as the Guantanamo litigation underscores, but they have also gone outside of the federal courts by choice and by necessity, targeting other venues of influence to advance human rights agendas, notably the United Nations human rights system and the inter-American human rights system governing countries in North and South America. The range of tactics that advocates use slides along a spectrum of legal advocacy: traditional litigation, where there are domestic legal hooks and acceptable targets; quasi-judicial international tribunals, when the goal is to enlist international pressure and gain the imprimatur of legal authority; and grassroots activism, when local legislative actors are more amenable to human rights claims. So there is, on one hand, a high-stakes effort to embed international law in U.S. law, both through efforts to force U.S. courts to accept human rights law as a basis for adjudicating disputes, and to use human rights to hold up a mirror to U.S. practices that are deemed out of step with international norms. In addition, public interest lawyers have increasingly ventured outside the U.S. legal system to raise human rights claims in international venues, reflecting both the constraints of litigating human rights claims in domestic courts, as well as the desire to connect with foreign allies and mobilize the authority of international tribunals. The main advantage of this strategy of moving outside of the U.S. law system is that it removes much of the complex legal maneuvering that stymies domestic litigation, permitting human rights claims against the United States and its officials to be aired without assertions of immunity or formalistic substantive limitations. The costs, though, I think, are significant. International bodies are subject to immense political pressure by the United States, impose their own jurisdictional hurdles, and are handicapped by their lack of enforcement powers. As a result, U.S. lawyers enter these arenas, international arenas, facing a set of trade-offs, able to fully adopt the rhetorical power of human rights and operate within a quasi-judicial form, but unable ultimately to translate that power into the implementation of hard legal reforms. Unlike U.S. litigation that attempts to achieve a judicial determination binding on the parties, the process of petitioning international bodies is designed to achieve distinct objectives: publicizing U.S. wrongdoing, generating international pressure on U.S. actors, influencing the administration of U.S. justice, and galvanizing domestic constituencies to mobilize for reform. Parallel to the human rights system, we have seen the creation of new transnational arenas of economic activity that have also produced, I think, new opportunities for public interest lawyers to enter into transnational advocacy networks that seek to mobilize law across borders. As I mentioned before, the expansion of free market arenas has facilitated the exportation of U.S. corporate activity to deregulated geographic spaces where it escapes the full force of U.S. law. Within these new arenas of U.S. economic activity, the main focus of public interest law becomes upgrading systems of legal governance and regulatory enforcement outside of U.S. borders. So this involves advocating new theories of U.S. jurisdiction to hold corporations abroad accountable, to enter into new venues of global economic governance, such as the NAFTA system and the World Trade Organization, and building alliances with transnational activist networks challenging market integration from below. In this sense, transnational economic activity is shaping new forms of transnational legal advocacy, with public interest lawyers following market activity outside of U.S. borders into regional and global economic arenas. So here, this adds some complexity to our pictorial representation of public interest advocacy in the United States. Probably much more complexity than you want, but we may think here about this graphically as movements away from, again, the traditional public interest model, which focus its rights and regulatory strategies on federal judicial enforcement. With greater internationalization, I suggest that the rights project of public interest law has moved from enlisting federal power to protect minority rights in the U.S. to contesting federal power through the domestic application of international human rights. Thus, we see here that lawyers are moving into human rights systems with the goal of placing international pressure on the federal government to change policies, particularly around issues of national security and the war on terror in the United States. Simultaneously, with the export, so that's here, drawing upon supranational institutions to place international pressure on the United States from above. Simultaneously, with the exportation of U.S. corporate activities, we have seen that the regulatory project of public interest law has become more focused on setting the economic rules of the game for internationally mobile capital, both through innovative efforts to impose corporate accountability through human rights litigation, so radiating U.S. law outwards to different countries to hold corporations accountable, and through the creation of transnational networks that operate to embed social standards in trade agreements and international financial institutions. So viewing the contemporary public interest field in this way suggests that far from giving up on legal advocacy, lawyers are in fact redefining themselves in new ways that leverage new opportunities for reform. To illustrate this, let me refocus for a moment on the tactical choices of public interest lawyers in the international sphere. Public interest law in the global age is characterized, I believe, by three important tactical shifts toward greater tactical pluralism, what I'll call polycentrism, and I'll describe that in a minute, and the creation of new alliances, cross-border alliances. With respect to the notion of pluralism, what emerges from a review of public interest lawyering in the international arena is a portrait of practice in many ways at odds with the traditional criticism of public interest law as too quick to invoke rights-based litigation. First, this type of lawyering is not defined by a litigation-centered perspective. Instead, litigation is generally viewed as part of a broader repertoire of advocacy techniques that lawyers bring to bear, often in complementary and politically sophisticated ways to solve problems. Second, rights are viewed not as ends in themselves, but as a means to advance defined political objectives, deployed pragmatically to spur collective mobilization. So in contrast to the traditional focus on litigation, lawyers in the international sphere readily incorporate non-legal techniques, organizing, policy advocacy, publicity, to advance their goals. The emphasis on multifaceted advocacy over narrow legal representation is a product, I suggest, of both strategic necessity and tactical innovation. To the degree that public interest lawyers find domestic courts inhospitable, alternative strategies are a must. As lawyers move into what they view as more receptive fora, such as the human rights system, traditional strategies do not apply with the same force. And non-traditional techniques, such as lobbying and reporting, are in fact required. And even in contexts in which domestic courts are technically available, the perception of their limited effectiveness prompts lawyers to supplement legal with non-legal strategies. The complex nature of transnational problems in particular, which cut across multiple jurisdictional boundaries, also invites flexible responses. In the environmental context in particular, the transnational scope of environmental harm causes lawyers to approach problems from the perspective of an advocacy campaign rather than a narrow legal case. The current wave of international practice also challenges the claim that the pursuit of legal rights necessarily co-opts more transformative, broader-based legal and political action. As the domestic human rights movement highlights, I think, lawyers are both sensitive to the potential political risks of rights strategies and skillful in deploying rights in flexible and pragmatic ways to leverage short-term political gains and stimulate longer-term political mobilization. Thus, rights are not simply viewed as claims to be invoked in court, but are also seen as resources to help frame policy demands and to help motivate grassroots action. Yet while the pragmatic use of rights that I'm suggesting can complement political action and promote solidarity, I think it's worth emphasizing that we should not be blind to its potential to reinforce existing fault lines. So some proponents see human rights universality as a means of transcending the divisions and responding to the failure of identity politics in the United States, and thus opening a path toward building a politically viable progressive movement. This embrace of universality, however, raises familiar concerns of ethnocentrism. Whose universality is being proclaimed, and does universality suggest a retreat from the deep engagement with the persistent and differential experience of domination and discrimination? Accordingly, those groups that have moved most forcefully into the human rights arena in the U.S. are ones that have never been identity-based. Lawyers at identity-based organizations like the NAACP, for example, in contrast, have struggled more deeply over the importation and the use of human rights, with the standard bearers of the civil rights movement stepping with great circumspection into the human rights domain. So the reluctance to engage human rights is a matter of strategy as well as principle, with some advocates for identity-based groups fearful that the move toward human rights signals a retreat from the cause of building strong domestic laws. And finally, despite efforts to merge the different strands of advocacy, the universality of human rights remains in tension with the partiality of other types of rights claims in the United States, such as immigrant rights, which calls for a recognition of difference rather than its submersion. So tactical decisions, how to advocate, are framed in the international arena by locational decisions, where to advocate. It's often the case that a lack of alternative options dictates the locus of advocacy, yet the move into different venues is not simply a matter of lawyers being pushed out of domestic fora. Instead, groups may choose to enter international venues out of an effort to influence international decision-making processes that impact client constituencies. In addition, international venues offer alternative platforms from which to assert political pressure for domestic gain. This polycentrism, the proliferation of different centers and venues in which lawyers can advocate in the international realm, invites lawyers to move into multiple arenas where they're required to calculate the strategic costs and benefits of their action, weighing which venues offer the most possibilities for politically meaningful intervention. In undertaking this calculation, lawyers balance aims of enforceability, legitimacy, and publicity. The question of enforceability implicates debates about hard versus soft law strategies and their relative merits. So, do lawyers turn to venues, to sites that have the capacity to issue directives that are binding on state and private actors and have clearly defined methods of enforcement, so-called hard law? Or do they opt for venues that lack mechanisms for directly constraining action, but nonetheless establish norms and offer opportunities for participation that promote negotiation and flexible compliance standards, so-called soft law regimes? Public interest lawyers operating on the global stage have so far resisted this either-or dichotomy, looking instead for ways to enlist both hard and soft law systems in mutually reinforcing ways. Even when advocates enter soft law venues, I suggest, it is not always the case that they do so simply with an eye toward promoting political pressure and using it to leverage political change. Rather, some groups have also sought to harden soft law systems by expanding the possibilities for legal enforcement from within. The clearest example of this has been in the context of the North American free trade agreement system of adjudicating labor disputes, in which early advocacy efforts unsuccessfully but attempted to push the system to enforce binding system decrees. So engagement in soft law venues may therefore reflect not just a commitment to flexibility, but also an effort to transform the venues themselves. Enforceability is not the only metric for evaluating engagement with international venues. To the degree that the choice of venue is made to advance a political cause, a central question is how venue selection may impact the audience that advocates seek to influence. At times, that audience may be a group's own constituency, which the group seeks to mobilize by using an international decision to publicize a cause and galvanize grassroots action. In other contexts, venue selection is designed to put pressure on an identified set of corporate or political decision makers. So there the strategy is to use an international venue's authority to spotlight wrongdoing and legitimate grievances, bringing negative publicity to bear in an effort to force decision makers to take remedial action. The pattern of public interest alliance building that has emerged in the global area reflects the border-crossing logic of globalization, with lawyers engaged in collaborations that traverse geographic, organizational, and professional divides. At the most basic level, alliances provide more resources to undertake advocacy and implement victories. So strategic alliances have the potential to increase the visibility of particular campaigns while providing public interest lawyers with greater credibility in front of decision makers and community members. In the global era, the transnational scale of advocacy makes alliance formation more complex, with lawyers required to navigate greater distances in foreign cultural terrains. But globalization also diversifies and improves channels of communication in ways that help to facilitate new cross-border relationships. The ability to quickly communicate across time zones and send large documents via email allows lawyers to overcome the logistical concerns attendant to cross-border advocacy. One dynamic in alliance formulation is collaboration between nonprofit organizations and for-profit law firms. These types of alliances are, of course, not limited to the international arena, but some have emerged in response to the particular demands of internationally oriented practice. In human rights cases against transnational corporations, in particular, for-profit public interest law firms have been crucial players, fronting the costs and shouldering the risks of resource-intensive projects that require coordination across significant geographic and cultural distances. Big firm pro bono lawyers have been important allies in domestic human rights cases, providing attorney resources for human rights litigation on Guantanamo detainees, gay rights, and the death penalty, among other cases. Global interdependence has also shaped the formation of alliances that cut across conventional professional lines. Lawyer-non-lawyer collaborations have developed in response to the distinctive needs of specific advocacy projects. In the immigration context, for example, lawyers have collaborated with organizers in boycotting employers to pressure settlements in labor violation cases. Lawyers also seek out non-lawyers to make up for resource deficits. So in the U.S., as in other countries, lawyers have consistently turned to university-based programs for student support in pursuing more experimental international human rights litigation. Advocacy around international issues has also blurred conventional programmatic distinctions and produced, I think, very interesting coalitions that cut across professional categories. The concept of human rights in particular has infused multiple public interest law disciplines in the United States, cutting across traditional civil rights, civil liberty, poverty law, immigration law, and other disciplines. So what I've suggested so far is that these transformations in the contemporary public interest law system, from political opposition to strategic adaptation, from economic transformation to internationalization, and from disillusionment to pragmatism, reflect a dynamism that is reshaping lawyering practice in the U.S., moving it toward a more supple, nuanced set of strategies that target different layers of domestic government and venture into the international arena in the pursuit of social justice. I promised you that I would try to draw out lessons from these transformations, and I want to leave you here today very, very briefly with what I believe are three central lessons that we might draw. The first I suggest is the notion of complementarity. If the current wave of public interest law teaches anything, I think, it is that lawyers are thinking hard about how to plug themselves into movements, how to work with broad-based organizations, and how to deploy law in ways that reinforce rather than undermine politics. This is an important ideological shift and one that I think bodes very well for progressive movements. It is also important to reiterate that complementarity is the model of social change that's being aggressively pursued by the opponents of legal progressivism, who have deployed legal action in support of deregulation, social conservatism, and expansive notions of executive power. This is to say that the political left, in some respects, by becoming so focused on the negative impacts of law on social movements, has perhaps missed the forest for the trees. Legal advocacy is folded into larger political mobilization in a way that cannot, and I think should not, be extricated. As public interest lawyers, we must think of ourselves as partners to other social change actors, organizers, lawmakers, judges, and not rivals. We must see our efforts. We must see that our efforts are not necessarily in tension with other forms of political action, but rather subject to the same forces of political opposition. Thus, whether social change is made through legal or political advocacy, it is always vulnerable to strategic reinterpretation, non-enforcement, and political backlash. This is a product of power inequality, not the inherent weakness of law. Thus, what we should take away from the current movement is that social change strategies, by definition, are ongoing and complex, constrained not just by their legal form, but by the very limits of democratic governance. These efforts suggest a second lesson, that legal activism is not simply a matter of changing law on the books, but changing systems of legal enforcement. This means that lawyers must think not just about gaining legal victories, but how to consolidate them. This means not just investing resources to monitor legal enforcement, but more fundamentally thinking about ways to preserve or alter the political balance of power so that it favors the causes that public interest lawyers pursue. This is perhaps another articulation of this complementarity point, but here the issue is that lawyers must play different roles, stepping outside of their legal professional role at times to support and defend the legislative and judicial processes in ways that are consonant with their legal advocacy aims. Most obviously, legal strategies are impeded by inhospitable courts, and lawyers have to fight to keep judicial venues open. But more broadly, lawyers must be attentive to the art of legislative compromise, regulatory drafting, and electoral politics so as not to lose the very foundations upon which legal advocacy must proceed. Finally, this leads to the idea of constancy. I think when one speaks truth to power, it is never the case that power yields lightly. A central lesson from the American experience with public interest law, then, is that legal battles as a vehicle of social change are ongoing and constant. It's never the case that legal victory definitively resolves the matter. It's always just an opening salvo in a longer political drama. Legal victories are not etched in stone and must be monitored and protected from counterattack to be sustained. This was true as much in the early days of the public interest law movement as it is now. In this sense, the contemporary stories of strategic adaptation and internationalization can be viewed as but the most recent chapters in the ongoing struggle to use law to reform politics, a struggle in which public interest lawyers are always operating from a politically weak position. To be sure, these transformations that I've described underscore the extent to which liberal rights advocacy has fallen out of political favor. However, I would also suggest that they are a beacon of hope, a measure of the resilience of the public interest law movement, which has embraced new strategies out of a sustained sense of commitment to the long-term struggle of claiming the legal arena as a site of progressive change. Thank you, and I'll be happy to take any questions if time permits. Or I spoke so fast that no one understood a word. You want me to repeat myself? Stunned silence. I'm sorry?
Will it be possible to arrive at this ideal result?
Do you want me to? You want me to predict the future?
No, think in a logical and realistic way.
Well, I think that what I've tried to suggest in my remarks and what I've tried to pursue in my research is the idea that if we look at what's happening on the ground, there are very positive developments that I think suggest movement in the right direction. So whereas the overarching dialogue and discourse about public interest law from a scholarly perspective at least is very pessimistic, I think what lawyers are doing on the ground is actually a quite optimistic story of speaking law to power and advancing social change in meaningful ways.
Very new arena, at least for lawyers here in Israel, and if you could just give a few examples of what has worked, what has not worked.
Sure. I think the best example from the United States context is advocacy within the system of free trade that's constituted by the North American Free Trade Agreement, which creates a free trade market between Canada, the United States, and Mexico. It also has set up adjudicatory processes for adjudicating disputes over labor and environmental harms. And the way that this process is set up requires that lawyers cross national borders in order to dispute their claims. So if I'm someone in Mexico who has a labor dispute, if I'm trying to organize a union and I'm fired because of my union activities, I actually have to go to the United States or I go to Canada in order to have my claim heard under the North American Free Trade Agreement. So this requirement of crossing boundaries in order to adjudicate disputes, in order to bring claims, has created momentum, at least, for the formation of cross-border alliances. Because if I'm in Mexico and I've suffered a labor grievance, I have to go to the United States, and that has typically meant that I have to find legal counsel in the United States. And there are certain public interest law organizations that have developed to facilitate these kinds of claims. And the situation has also operated in reverse. In the U.S., there are a number of claims alleging violation of immigrant worker rights, Mexican immigrant worker rights, that have then gone to Mexico and raised those claims in the NAFTA system within Mexico, and has seen the formation of alliances between public interest lawyers, immigrant rights lawyers in the United States, and their counterparts in Mexico, seeking to raise the issue of the treatment of migrant workers in a way that resonates with both countries. So I think both of those examples on the labor and sort of immigrant worker front suggest ways in which changes in the economic arena and the expansion of free trade policies and some of the adjudicatory systems that free trade policies require has actually knitted together activists across borders in ways to promote the kinds of cross-border activism that I've suggested. So, yeah.
Could you elaborate a bit more about the way those lawyers, public interest lawyers, can affect institutions, international institutions such as the International Monetary Fund, WTO, ILO, where any decisions are taken on transnational level, and where you have problems such as lack of transparency and lack of accountability, and how public, even via NGOs, can affect such institutions.
Yeah, I guess there you'll notice that I didn't mention that too much in my talk, and I guess that's an arena where I feel more pessimistic than optimistic, given efforts to both open the World Trade Organization and the World Bank to NGO participation. I think some of those efforts have proven successful in the sense that there are now formal opportunities for NGOs to intervene in disputes in front of those bodies, although I think in terms of the experience of American NGOs that have gone there, a lot of them have sort of pulled out of that process for disillusionment and frustration with their ability to actually affect the way that the institution runs and organized. So in terms of legal intervention in international financial institutions, I think the story hasn't been that positive so far, and perhaps that is an area where political action and political mobilization might be the more effective strategy. I think if we move away from international financial institutions into the system of human rights, that's an area where I think these transnational networks and entry into international venues has actually produced positive results. At least, again, sort of confining my story to the United States. because the UN in particular, and in the United States, the Inter-American Commission, have significant institutional legitimacy, and lawyers have been able to go there, groups like the American Civil Liberties Union in particular, and gain definitive rulings from those bodies that they have then brought home and used to mount public relations campaigns that I think have contributed to momentum in favor of political change, particularly on issues of national security and the war on terror. So I think that sort of the idea of importing human rights and using human rights venues to leverage change in governmental action in the United States has suggested sort of a more favorable trajectory than this question of intervening in international financial institutions with authority over economic issues. Yes?
I very much agree with what you said about changing the system and the need to shift into much more enforcement than winning cases in court. The thing is that we need much more resources in order to change the system. And do you have an idea of how it works where you come from?
How we get more resources?
Yeah.
Beg?
It's not commissions, like 100 commissions. I need like 10 lawyers.
Right.
So how do you do it?
I think it's very tricky, and you have to be very creative, and I don't have a definitive answer. I mean, I think the U.S. experience in this respect, it may be aberrational or unique to the degree that it is a very large institutional system, and there are very large organizations with huge budgets, particularly if you look at environmental organizations. There are hundreds, if not thousands, of lawyers in some of the major environmental organizations in the U.S., and they have significant political power. So it's not just a matter of being able to effectively bring lawsuits, but also to intervene in the legislative and regulatory process in a way that actually has promoted effective change. Now, I think that's a differential strategy. So some groups that have sort of more politically popular causes like environmentalism are able to deploy that, while other groups that have more marginal political causes like immigrant rights in the United States, for example, have a much more difficult time in order to advance those kind of strategies. I think one thing that groups have done is to try to create this sort of creative alliances that I've suggested. So in the immigrant rights front, I think one of the interesting developments that is suggested by the transnational networks that I just talked about is that lawyers in the U.S. are actually cultivating relationships with Mexican governmental officials because they care deeply about how their nationals are treated in the United States workplace. And they also have resources and political influence. So part of the story, I think, is a matter of looking strategically to individuals and groups that actually have authority and resources and trying to persuade them to be on your side. And I know that's a complicated proposition and one that doesn't work always with different sorts of causes, but I think the American experience suggests that with some creativity, it can work in particular situations. Yeah. No, I think I would definitely predict that there will be opposition, and there is opposition in international venues. International financial institutions are the clearest example, but you've seen the debate around the Human Rights Commission in the United Nations and the U.S.'s effort to change its fundamental mandate so that it doesn't have as much authority to review U.S. actions. I mean, I think it's clearly the case that the U.S. has at the federal level at least, has moved into these institutions and tried to circumvent their power and restrict it in a way that we've seen at the federal level. And yeah, I mean, at the local level too. And I guess what I want to suggest is that this is typical, predictable, and something that public interest lawyers have to not only anticipate, but also sort of deal with and find the resources and strategic energy to deal with on an ongoing basis in order to, again, sort of consolidate and protect the gains that it has created in different venues. Yes, that's going to happen. Yes, it is already happening. And I think that reinforces one of the things that I wanted to try to centrally and fundamentally convey, which is that we need to think through how this will happen and to target resources and strategies in such a way that can protect these venues from intervention from conservative advocacy groups. And if the gains of public interest lawyers on the left are undermined, figure out ways of making advances. Other questions? Okay. Thank you very much.